Hello YouTube, I'm Vince White. I am an employment attorney and we are answering publicly posted questions from YouTube users. Excuse me. Getting folks the answers they need from employment attorneys. We have a question from YouTube user Pamaroon. Oh, and I'm supposed to tell you to like and subscribe. If this video is helpful, like and subscribe because that would help me to help more people just like you. So, YouTube user Pamaroon asked us, I had a friend who was dealing with a sexual harassment lawsuit and was on contingency with the attorney, I presume. But then had to pay a fee for her depositions against the defendants. Is that something you are aware of? Yeah, so that is, in fact, something I am aware of, and I will explain how and why. There's a lot of different arrangements, right? You can kind of go around. Some of the non-attorneys who talk about EEOC issues on this site will describe like the various retainer agreements they received from different attorneys and their experience shopping around. And I know a lot of the back end of that, and like I see people's retainer agreements when they're like coming from other firms, or when sometimes people will get like a retainer agreement from a firm and then shop it around and be like, hey, can you beat this? And I'll get to read retainer agreements and stuff like that. So I see a lot of retainer agreements, a lot of arrangements for payment for attorneys for different things, right? The simplest arrangements, of course, are always going to be if you're paying the attorney hourly or like a flat rate for all whatever work they're doing. But often that's not what we see in this field. We often see contingency, which means the attorneys take a percentage of what they win for the client. Now, there's a key issue tied up in that. Who's paying the expenses? And some firms will have the client's front expenses. To me, this is not wise, and I very much try to avoid this. But some firms don't have the war chest, we'll call it, that our firm has, right? So I'm not saying there's anything wrong with this. To be clear, it's not ideal. I think from the law firm's perspective, it's not ideal. You never want to be running around telling your clients, give me the money, we're here to win money, right? We make our money by winning the money. Then we keep a percentage of what we win. And when you're running around saying, give me money, like it's not, I hope that's not a accent to an actual culture. I don't believe it is, but okay. Anyways, it's not ideal, but it is something that a lot of firms do, because a lot of firms listen. When I was starting out, and I was doing when I started my firm, I was doing employment law, which is what I did, but I also would run like bankruptcy cases and like simple retail bankruptcy, like Chapter 7 stuff, and the occasional criminal case, right? All of which I felt confident in being able to handle. And at that stage in my career, knowing that for me to like continue to live and eat and have like a roof over my head, I had to do X amount of cases per month. There was no chance that I would be able to say to a client, yeah, let me just cover everything. There's no way I could have done that, right? I mean, how my month went determined which kind of peanut butter I could buy at that stage of my life, right? I live with some lovely people in a house in Long Beach, New York. Wonderful folks. We were just 6 grown adults in a house, all with our own bedroom, right? Like it was, things were tight, you might say. And the idea that a client would come in and I could just say, I'll cover everything, not a chance. So I am not by any stretch beating up on a firm that goes to their clients and says, yeah, so as per our deal, we're on contingency, but you have to pay fees, and this court reporter is pricey. So here's how much you have to pay for the court reporter. You're not paying the attorneys necessarily. I suspect, Pamaroon, I don't know what's going on. I'm not there. I don't know the arrangement with your friend. I suspect what they're saying is, hey, pay for the court reporter. Or even sometimes there's a videographer, there's a telephonic suite if it's remote Zoom depositions in certain situations. There's all kinds of things that go on that have to get paid for sometimes. Also, sometimes if it's expert witnesses, you have to pay expert witness fees. And that is what I suspect is going on. They're saying, hey, we're on a contingency, but you gotta pay the expenses. We can't front them for you. The other thing that could be going on and I've seen this, is that there are attorneys who will like take cases with stepped retainers. So it'll be like, hey, we'll take your case and we'll take our percentage of whatever we win for you. But if we have to do a motion to dismiss, it's going to be X amount of dollars. And if we have to do depositions, it's going to be X amount of dollars per deposition. And then if we have to do summary judgment motion, it'll be this much. And then if we have to do a trial, you owe us this much before we do the trial. Often, even before you do trial prep. And I don't love that arrangement. There's nothing fundamentally wrong with it, except that there's a lot of guaranteed money for the attorneys. And in this field, we ought to, in my opinion, my not so humble opinion, my opinion should be humble, but it's not. I should be humble. I've got nothing to be braggadocious about in all the world, but I'm too dumb to be humble. So, in my ought to be humble opinion, we ought to be winning money for our clients, and that's how we make our money, right? We ought to be winning our money. And when you get into big chunks of guaranteed money for attorneys, it's not my favorite. It's not ideal. I get why certain attorneys do it, right? Like, they need to live. And if they're working on this case, they can't work on another case, and they might be making a decision between an hourly case and this contingency case. So they're trying to help the contingency person. They're trying to cut a deal that will let them continue to survive. I get it. Things happen. Like, this isn't like charging for consults. And to me, I think charging for consults in this field is reprehensible. I don't think this payment arrangement is reprehensible. I just don't love it. That's all I'm saying. I get how it happens. I get why it happens. Just, we're living. We're human beings. We have basic biological needs like food and water and shelter. And some firms are going to structure payment plans and payment arrangements and retainers in certain ways. So I'm not attacking them, but that's the other thing that could be going on here, Pamaroon. I suspect it's just paying court reporters and things like that, and maybe an expert witness fee, but it could also be paying the attorneys to conduct the depositions as some kind of step retainer arrangement. And your friend should be able to just review the retainer agreement and see which it is, or if she or he trusts the attorney, ask. But I would always say review the retainer agreement. And if it's not in the retainer agreement, as far as I'm concerned, it didn't happen. Like, there's no we have a retainer agreement, and then the attorneys come to you and be like, well, a little extra money for me though, right? Give me the money. Like, no, that's not a thing. If it's not in the retainer agreement, it didn't happen. And which is like an old internet meme, pick or it didn't happen. Like, if there's not a picture of it, it didn't happen. In this field, it better be in the retainer, or it's not gonna happen. Like, it's no way. I hope this is helpful. I hope this answers your question. Good luck out there. I hope your friend gets money. Take care. Oh, like and subscribe.